Marc Gross is a partner at Fox Rothschild, a national law firm. With more than 3 decades of experience, Marc focuses his practice on business litigation and the management of legal issues in crisis situations. He routinely represents a diverse clientele that includes entrepreneurs, closely held family businesses, automobile dealerships, and real estate and technology ventures. I've known him and referred him for, man, Marc, I think it's at least 15 years now.
It's more than 15.
Is it more than 15?
It's approaching 20, but that's my recollection. Somewhere between 15 and 20 years, you and I met.
We were both a little less gray when we first met. Well, anyway, welcome to the show.
Thank you, Mike.
So today we're going to focus on some elements, and especially one element of employee decisions and the law that has frustrated me for a long time. And Marc is either going to frustrate me more or clear things up for me. Well, we will see. But first question I always ask, lawyer or not, first question I always ask is, Marc, from all of your experience with leaders, leadership teams, and in your own partner in your own firms for many years, what do you believe is the one most important characteristic of a great leadership team?
Wow. Okay. I think the big C, communication. If the team can feel free to communicate with each other without fear of rejection, reprisals, mockery, you're going to have a great team. When the members of your team are able to provide different opinions, communicate that, your leadership team will generate decisions and take actions based on all different opinions of your team. And I think that's always helpful in terms of moving a great business forward in the right way.
Beautiful. And I'm sure as we move forward in the conversation, effective communication, I would imagine, is going to be one of the anchor characteristics that we'll probably talk about throughout. But I'm going to dive right into something that has frustrated me for many years, which is leaders that keep poor performers because they're very low in productivity, poor performers because maybe they're a very low culture fit for whatever reason. Leaders who keep poor performers around too long, and when I see too long, a year and a half, 2 years, and their excuse is, I don't want to get sued. So we can't let this person go. They're in a protected class. We can't let this person go. And it drives me crazy. So
it's also a drag on any organization, right? So there's a view that you're only as good as your worst team member. And so keeping a poor performer around is going to bring everybody else down and oftentimes suck energy out of the leadership team.
Yeah, I'm with you. You're preaching to the choir. So we're on. So far, you're not frustrating me. This is good. I like it. But help me understand, why is it that leaders feel that way? What is it that they're hearing? And maybe you could say what they're hearing, and then maybe there's a different way to interpret it. But what is it that they're hearing from their attorneys, who I know are just trying to protect them from a lawsuit? What is it they're hearing that's causing them to throw their hands up and say, well, I really just can't get rid of this person?
So I can't tell you what leaders and business owners are hearing from their other lawyers. What I can tell you is advice that I give to my clients. And that is, if you're having issues with someone on your team or any employee, let's move down the alphabet. C for communication, but D, document are the three most important things. Like in real estate, the three most important things: location. In dealing with a problem employee, it's document. If you have someone that is not performing in the way that you want, document it in an email, in a review, in an evaluation. And it doesn't have to be once a year on the annual review. It should be when that poor performer engages in some conduct, takes some action, or even an omission that flies in the face of the mission of your business. You've got to document it as a leader of that team. With enough documentation, after some period of time, and it's on a case-by-case basis, you can make a case that your termination of that employee is for a non-discriminatory reason, but because of poor performance. And you'll have the documentation to do it, to support it.
So let's dive into that and get really specific. So let's say I've got someone working for me that is, let's say it's a salesperson. Let's take something that's easily measurable. I've got a salesperson. They have gone 3 quarters in a row, not hitting their sales goals. I have tried to coach them without much luck so far. And I'm finally at the point where I'm like, maybe this is a bad fit. When you say document it, now I actually advise my clients that annual performance reviews and quarterly performance reviews are the worst invention ever created in business, which is a whole separate topic. But let's assume based on that, that this is not about some formal performance review, just at the point where I'm saying, this just doesn't seem to be working. I've got to have a conversation, not a conversation to fire them yet, but a conversation which is, hey, let me let them know they're not hitting their goals. And, we may have to have a difficult conversation later. Whatever that conversation is, when you say document, if you're my employee, I sit down and have a conversation with you and I say, okay, is November 15th, at 4:10 p.m. I had a conversation with Marc Gross, told him he wasn't hitting his sales goals, coached him on how he might do it in the future. That's my documentation. Is that enough, or is there some more
It's a
formal way to document?
It's a start. What you're with the entity that you're having the coaching relationship should do, and it's not a sales pitch for me and or for you, but yes, documenting it to an HR file is the first step. You also should put some sort of writing together, either in a hard form or electronic, confirming the conversation that you had with that employee. And often advice I give is to put together an employee, some sort of improvement plan. And you want to put in writing the things that the employee is not doing, failing on, the issues, and document what the employee needs to do, a personal improvement plan in order to get up to speed and what the timeline is for that. And that's the first step. And then the next step is when the employee fails to meet those marks in the time frame set forth in that document, now you have another meeting and you document that you documented with the employee that they failed to meet these marks. And you should.
Well, let's go back. So this is good. This is helpful. So that first document, which to your point is a little bit more than had a tough conversation with Marc Gross today because he's not hitting his sales goals, more to come. And here's the date and the time. It's what's that performance improvement plan? When I do that and say, here are the issues, here are the 3 ways we talked about improving, and here's when I need to see the improvement by. Is that enough? Do I need to now show my employee this document and they now need to sign it?
You don't have.
Or is it enough that I've got it for my files that I've had the conversation?
Okay. So first, I should have said this at the beginning as a lawyer. None of this is legal advice. Every circumstance is different. Go see your lawyer. And what I'm telling you is not legal advice. Okay. So with that being said, you can't rely upon anything that I'm saying. Now with that being said, it's great to have it internally memorialized. That's lawyer speak for written down somewhere in your file, in your HR file, but you should also give it to the employee, some form of documentation confirming to the employee what you spoke about, what the issues were. God forbid there's a problem 6 months, 2 years, 3 years later. You're going to have now this document in the employee's hand, and more likely than not, no response from the employee, rejecting it or saying none of this is so, it was made up. You're confronting me not because of my poor performance, but because I'm some sort of class of person that is being discriminated against. And so it's a great thing to do, have your internal document, and that should also be very similar or perhaps the exact same as what it is you're providing to your employee, and you just keep a copy of that discussion. Your second question was, do you need the employee to sign it? Well, that's something beyond your control. Sometimes employees won't sign it ever, not give it back to you. Don't plan on it. I don't like ever giving somebody the opportunity to sign it because then they can cross it out, reject things. I would provide them with the email or memo that confirms the discussion, nothing to sign to come back. Again, it's not legal advice. It has to be, everything is on a case by case basis. Every situation is different. These are just general guidelines and some tips, I guess, on how to move forward. It's not impossible to fire a poor performer. It happens every day. And I would say, it's at least once a month, maybe 2 or 3 times a month, where we're getting that issue raised here. How do I get rid of this sales manager? How do I get rid of my CFO? How do I get rid of the president of the company when it's a family business and it's the chairman of the board who wants to get rid of the president? Or how do I get rid of my receptionist? Whatever it is, the skill set and what you have to do is the same. You must document it, provide the employee with a copy, set goals and a timeline, and follow up.
And that's whether you believe they're in a quote unquote protected class or not.
That's right. Whoever it is, just do it. It's good practice.
And I think that's where, as logical as that is, and as logical as it sounds, I think that's the first place I see leaders fall down, is not only in not doing that documentation, but more specifically, the reason they don't do the documentation is if I have to sit down with an employee and have a tough conversation, I can do that. But documenting that conversation and showing the employee, okay, here's the document, whether I'm asking them to sign it or not. Hey, just want to make sure, you've got what I've got. We've documented this conversation. I've asked you to do these things. Now, all of a sudden, it elevates this discussion. I know if I'm the employee and my leader sits down with me and has a tough discussion, we're going to have that discussion. I may feel like crap afterwards, but we had the discussion. I appreciated he had that discussion. When he hands me a piece of paper and says, here's the discussion documented for our records, all of a sudden, I may be dusting my resume off because I'm starting to worry that I've got a bigger problem. And I want to hit that because I don't want to jump to the point, and we will get there, but jumping to the point of now it's time to potentially make the decision to fire someone. The problem is the initial discussion, it's not necessarily about, man, I have to have this discussion so I could fire them. I'm having the discussion because I'm having some issues with this employee.
The employee may improve as a result of the discussion. It may be an aha moment for the employee that they better get their body in gear to perform at the level that the business expects that employee to perform. It could be an awakening.
Yeah, and I think you bring up the good point and the right point. That is important when leaders, when a leader listening to this says, "Oh God, now I've got to go from having a difficult conversation, which is hard enough. I'm multiplying it by 3 by now saying, here's the document." It makes it more serious. And on the one hand, making it more serious makes us nervous, makes it more difficult to do. But on the other hand, to your point, why not make it more serious to raise the challenge and raise the level of urgency for this team member to improve their performance?
So let me tell you one of the things that my dad told me many years ago. My dad was a serial entrepreneur, had a bunch of businesses. He would say one of the worst things for an organization is to have illness from within, with a bad partner, a bad shareholder, a bad employee at a senior or critical position. He would align it to like an incredibly sick patient, cancer. And either you have to treat it or cut it out. You've got to treat the cancer or cut the cancer out. If you don't, you just get sicker and it drags down the patient. That's how he would analyze and analogize the business. So either you have to cure it or cut it out. And that's the best advice, although I'm not giving legal advice, but if I were, that's the best way that I would direct a client in that way. You have to address
and I think, and as I think about this, Mark, what it makes me think about is I'm in the midst of writing my 3rd book. And part of what's in that book is the importance of being crystal clear with our team members as to what our expectations are. of them. If it's a salesperson, how much new revenue do you want them to bring in? If it's a head of client service, what do you need the client retention to be? Let's get very specific and very measurable with expectations. And if we start that way, and if we create a culture of documenting expectations, documenting goals and actions that will lead to success, then it becomes almost natural, not almost, it becomes natural after a difficult conversation or in the process of having a difficult conversation to document that as well. And it doesn't feel so out of the ordinary, but it does exactly what we're trying to do. So you document that. So let's assume, so we have that, I have that conversation with my difficult team member. I document it. It's now in the records, in their HR file.
And in your employee's possession.
Right, because we've shared it with them. So we've got that physically or electronically. We've got that document. Now they continue to not meet expectations. Let's talk about timing. Do I need, 6 different write-ups over 12 months? Is one write-up enough? And I've given them 90-day goals. They haven't hit those goals. I don't think they could do it. Like how long and how often does this have to happen?
It is a great question, but it really is a case.
That usually means there's no good answer.
No, there's always a good answer and there's a solution, but it depends on what the infraction is. If it's somebody who is threatening other employees, making other employees uncomfortable at work, fearing for their safety, we're talking about an abusive person in the workplace, that's going to be very different from somebody who's not hitting sales goals. If your sales manager or your brother-in-law who's responsible for the sales of the business is abusive, you're going to need a different level of documentation, different timing, different amount than someone who's the brother-in-law who's not hitting the sales goals. So
when you say different, because one is very measurable, one is not. If someone's being abusive, how do you measure that? They're not hitting sales goals. You can measure that. Is that what you mean? Is it the measurable, or is there some different differentiator?
Look, a lot of this
there?
eventually is subjective. It's not a measurable thing when you go in front of, and no one wants to be there. Either an arbitration, if you have an agreement with your employee or soon to be ex-employee, that disputes are arbitrated, or you're going to be in front of a judge. It's going to be how that third party, that fact finder, is going to look at these set of facts. If you have the abusive or threatening, and I've had it on several occasions, dealing with one now. If you have that abusive, threatening person who's a cancer in your organization, you're going to have a different type of writing, different time frame. You have a duty to protect your business, your employees from somebody, and you have to act quicker. If you have somebody who's not hitting sales goals, but it's not a danger to the safety of other members, it's different. It's definitely on a case-by-case basis, and it's a feeling from doing this. From where I'm sitting, from doing it for literally, like you said at the beginning, decades, you get a feeling as to how judges or arbitrators will react to the set of facts that you're being dealt with. And you have to be able to adapt your solution and resolution that fits the problem. There's not one size fits all. There's not one solution. It's extremely fact sensitive. It depends on the employee, the class, the protected class, where the venue of any potential case, or who might hear it. Is it a judge? Is it a jury? Is it an arbitrator? What the issues are of that employee? And all this has to go into the calculus. Does my documentation include interviewing other employees or other members of my leadership team and get them to sign statements about what this person is doing or failing to do? And again, your documentation and the degree and how often and when to move to the next step depends on what's going on. It will change.
How much does setting expectations up front around behaviors, one of the things that a lot of companies have and that I work with my clients on, is a set of core values.
Right.
And not aspirational crap that's out on a website that just makes us look good, but true non-negotiable behaviors. This is what our culture is all about. These are our non-negotiable behaviors. We're going to respect each other. We're going to lift each other up. We're going to take accountability. Whatever it is, every company's different, but setting expectations on non-negotiable behaviors, setting expectations on measurable results, whether it's a sales role or a finance role or an operations role, whatever it is, setting those expectations up front, does that make things any
A
easier
lot.
if it does come down? I assume that, but logic doesn't always enter into the
Doesn't.
equation.
But
So I
but
thought I'd ask the question.
your instincts are right on this. It absolutely does. If you have core values, if you have your expectations, your job description, it's in writing, and your uh, colleague, shareholder, other member, partner, employee is not meeting these goals, these core values, the job description, that makes your life in terms of documentation or getting rid of this problem person or coaching the problem person to get a D or a C player to a B makes it a lot easier because everybody knows that you can't do this. Everybody knows that you have to hit this milestone. And if the person isn't doing it, everybody knows it. It's easier to say this person was terminated, let go, reassigned because this person was not meeting our core goals, the known objectives of the group, as opposed to this person was let go because they're too old or has a disability of some kind.
I know there's no one right answer to this, and we kind of I alluded to this a little bit earlier, but I want to hit it again because I think it's so important and such a frustration on the part of leaders I work with, and it's the idea of how long does it take? And I know there's not one right answer, but if there is a leader who has got an employee that is underperforming, they've had the conversation, they've documented it, it's in the file, the employee has seen it. A month later, they got together again and said, "Hey, there's no progress. I need to see progress. We're documenting it again." A month later, it's the same. I mean, is there some way to understand, hey, do I have to document this 15 times over a year or twice over 2 months?
Or
How
maybe
should we
once,
be
or
thinking? Or maybe once,
maybe
yeah.
once. Again, I know you're not going to like it, but the truth is, it depends on the person, what the class is that you're worried about in terms of discrimination, where that person is in your organization, what the behavior is, what the goals are. You know, typically it's not going to be once in terms of a write up or writing, and typically it's not going to be 15 times. It could be zero, depending on the infraction that you're going to let somebody go immediately. That if you find out that this employee has stolen or taken or misappropriated some sort of confidential information, you're going to let that person go right away. If you haven't, I want to see your employee handbook, but there may be no warning. And there may be a half a dozen warnings over 6 months. If it's something like not hitting sales goals, it may be over 6 months or a year. So there's a path to do it that depending on the person, the infractions, the circumstances, the goals, the core values of the organization.
And what's the danger? And again, I know there's not going to be one right answer here, but I'm going to give it a shot anyway. Is what's the danger of getting this wrong? And it's
It
probably
happens.
going to be different whether it's protected class or not protected class. But what's the danger of getting this wrong? And I'm asking for a very specific reason because there are times I've had leaders just, can't get rid of them. They're in a protected class and they're so worried. But this person, month in and month out, is wreaking havoc within their business. And they're already having an impact. They're losing maybe millions of dollars in revenue or productivity. So when we think about the ROI of making one decision versus another, and certainly the first course is do this right and document it. But what's the danger of getting this wrong?
So you can do it absolutely right, Mike, and still be subjected to a claim.
Yeah.
And so whether you're right or wrong, you might still find yourself on the other side of the V where you don't want to be. What can help deflect or mitigate that is insurance. There's insurance for this. And so I recommend it. Businesses should get it. And it will defray the cost, diminish your aggravation, and the risk involved for an enterprise if it has insurance on employment practices. And you got to work with counsel on it and make a determination as to what the risk is, whether you have insurance to cover either fees or a settlement. And is it worth it to your organization? Do you need to get rid of the person in order to move on in a way that's healthy for your business? It's a calculus of many moving parts.
Much more basic question. We are, and you tell me if this is if this is countrywide or maybe it's state by state, but my understanding is at least in New York and New Jersey, it is at will employment.
This is typically
Right.
nationwide. Yes.
That's nationwide.
I'm
So help me to understand, because if I look at just the high level definition of that, it says, well, I don't need cause to fire somebody. I can just fire them because I want to fire them. And I'm not suggesting people do that. But when we talk about at will employment and then we talk about the need to document, it feels like it's not really at will employment. So help me understand that definition and what it means and what it doesn't mean.
So you have an at-will employment where you have an employee that has a contract. You can have a contract with an employee, and it typically happens when there's a sale of a business where you'll have a contract with a senior person from whom you either bought the business from or some of the senior leadership team of the business that you acquired, and you'll have a contract to keep those people for a year, 2, 3 years. Those classes of people are not employees at will. You're obligated under a written agreement to employ these people for a duration of time. Absent something in writing like that, typically everybody else is an employee at will. There is another exception. There's some case law that talks about shareholders in a closely held business. And one of the reasonable expectations of a shareholder in a closely held business is the enjoying the fruits of the business and employment by the business. And if you have someone who's a closely held shareholder and has been enjoying a senior role or a role of employment in the business, there might be some reasonable expectation to continue in that role. And although you have no employment agreement, I've been in cases where it's harder than you would think to terminate a shareholder who's also an employee. So I don't know if I've answered your question.
Well, so you've given us the exceptions of where it's not at will, but where it is at will, which is going to be the majority of situations, help me understand that seeming disconnect between if it's at will, why do I need all this documentation?
Because if you're dealing with somebody in a protected class, somebody might claim in the litigious society that we live in that you're really being terminated, not because it will, or because you're doing a bad job, or because of layoffs, or there's a business reason. But the only reason you're terminating me is because I'm in the protected class of a national origin, gender, some sort of disability, age, and you're getting rid of me for a discriminatory reason. That's unlawful. And you can't do that. You can't get rid of people because you don't like the way they look. You don't like the fact that they might be disabled. You don't like their national origin or ethnicity, their religion. You don't like it that they're now old, and you can't fire people for an unlawful reason. You can get rid of an employee at will if they're performing poorly, or if it's not a member of a protected class, you can fire that person without worrying as much as to whether you're going to be on the other side of a V and either be sued or have a claim against you in an arbitration.
But I want to take what you just said. You said without worrying as much.
Well,
My interpretation of that, and I know you're not giving legal advice,
right?
But my interpretation
I've seen crazy things, even with people who are not members of a protected class, bringing claims against employers, their former boss, that are out there and that get resolved in the courts. And people will come up with wacky things, lies, in order to try and squeeze money out of a company. And so you have to be careful. It's just where we are now in terms of a society. People can sometimes sue or bring claims on small things, frivolous items, baseless issues, and try and squeeze some money out of a former employer. And they might find an employment attorney who's willing to take a case on contingency. And then there's a very little investment by the former employee and an upside that makes it worth it. That's why you have to make clear that there's a reason for the termination. It's just the safest way to go.
If and when you get to a point where there is a termination,
Where are all these
should
questions coming from?
I was just fired and I'm trying to figure out what to do.
Yeah.
If you get to a point, yeah, it doesn't say this isn't from real life, right? Like I hear this every day. Mike, it's complicated. This person's lost us $10 million over the last year, but it's complicated. You don't understand. So I want to understand so I can push back on them. But when and if you get to the point that you are terminating someone from the organization, and sometimes these are not necessarily jerks that you're firing, right? Sometimes they're really good people who you like that are just not, they don't have the capability to perform in the role that you'd like them to perform in.
I'll give you another example.
Well, hold on, let me.
Go ahead.
So
your shot.
the question I have, yeah, don't you forget it. The question I have is, when you are terminating that person, especially if you like them, you're going to want to continue to let them know why this is happening, right? You want to give them an explanation. The same reason sometimes if you're not hiring someone that interviewed, people say, oh, could I ask why? And people want to explain it to them. And I'm going to ask about that too before we're done, the hiring part. But if you're firing someone, should you, now, of course, if you've done all the documentation, it should be obvious what's going on. But when you fire someone, do you get involved in that discussion and give them a long description of why you're letting them go? Seems like the right thing to do, but is there something with that could actually get you in trouble, or something when you're explaining it you need to be cautious of so you don't get in trouble?
Yeah. Okay. So I think the question is, should you provide your departing employee with a long explanation as to why you're letting that person go? And typically the response, especially if it's in a protected class, is maybe. It's on a case-by-case basis. I really would have to understand it. I'll give you an example. A client of mine sold his business. He went on to work with the acquirer. Some of the executive team of the business prior to the acquisition was being let go. It's a very short explanation that the company has been sold. Your services are no longer needed, even to those who were in a protected class. And it was that's just in that circumstance how you would handle it. In other circumstances, if you have a more contentious and what you think might be a fight with that employee, my advice would be totally different. And it would be something much more lengthy and itemized and referencing all of the other prior memos, emails, documentation, incorporating those by reference, setting it forth in bullet points, the reasons for letting this employee go. Again, it depends on the employee, the circumstances, the concern about what protected class, where we are, what state we're in, what the alleged infractions are, the reasons for letting that person go. And then we would work with that client in helping draft the termination letter.
Is there anything else we haven't talked about, again, in this whole theme of I've got an employee that's underperforming and there is a chance I may have to let them go at some point? Is there anything else we haven't talked about that leaders ought to keep in mind so they can do the right thing for the company, the right thing for the employer, even the employee that may be getting let go or having an issue? Is there anything we haven't talked about that leaders ought to be thinking about?
Yes. Having a helpful employee handbook that is up to date with rules, regulations, policies, including policies relating to termination, what the core values are, the expectations for all employees. I have a client where we had a hygiene policy and we were able to let somebody go because of violation of the hygiene policy. There should be.
Hold on, I got to stop you there. You could give me more details on that. Did they smell,
Yeah,
or what?
well,
What was
without
the?
going into the details, the client was involved in a business where hygiene was important, and we included a hygiene policy in the employee handbook. And when someone violated that policy, they would get a warning and a period of time to improve because it could hurt the client's products and services. And if you didn't approve, you would be warned several times over a period of time and then let go. And if there's a claim, because, okay, you fired me because I'm a member of a protected class and not because I violated the policy or any policy, we would have witness statements, warning letters over an extended period of time that this person violated a company policy, had ample time to improve or change and did not. And we had no choice but to let that person go.
What I really wanted, Mark, was the juicy details of.
You're not going to
what
get it. I'm sorry. You're not going to get it. Almost every imaginable circumstance I have dealt with. And it's just a discussion maybe for over a drink and not a podcast where we.
All right. And don't worry, my audience, I'll after I get Mark drunk, I'll come back and share with you what the answer was.
Having a up-to-date employee handbook that would help a business go about protecting its rights, retrieving back from the departing employees a company laptop or cell phone or client list, what the policies are, what the routine is when you let somebody go, what the process is, what the reasons would be for, what constitutes a termination. That is extremely helpful. I can't tell you how often I'm surprised when clients come to me, particularly new clients who are referred to me, and they don't have an employee handbook and they got a problem. So sometimes what we advise is we put an employee handbook together with targeted policies, get that issued to employees, and then, a month or two later, start the documentation process.
And I would imagine the other thing, and this is where I thought you were going to go, being the great sales guy I know you are, is the one thing we haven't talked about that you need to think about is having a good lawyer.
Well, yes, for sure. But, every client that I've ever had has always had another lawyer before they hired me. But
I said a good lawyer.
That's the only pitch I'll make. I mean, there are lots of lawyers and it has to be a good fit. Every lawyer should fit well with the business, and, relationships are everything.
Talk a little bit more for those that are interested, and I'm sure everyone that listened, especially if they're still listening.
There's nobody still listening from my mom.
Yeah, if they didn't get value, they're probably not listening to this anymore anyway. But for those still listening that got value, talk to us a little bit more specifically about your practice, the kind of folks you help, the kind of work you do.
Okay. So, I mean, you've mentioned it a little bit at the beginning. I'm a business lawyer. My firm has 30 offices. I have a national practice. I have cases in Florida, in California. I've tried cases in Vermont. I've had appearances as lead counsel in Alabama, Knoxville, Tennessee. I can go on. Obviously, the core of my practice, and probably more than 80%, is New York and New Jersey. And it's strictly a business practice representing businesses, entrepreneurs, business owners, and every imaginable problem. I get phone calls starting usually around 7 a.m. till, after 10 o'clock at night. My clients become my friends. My friends are my clients. And, when you're representing somebody that you have a close personal relationship with, that's a friend, there's a different level of satisfaction. There's a different level of motivation to help solve that problem, and as fast and as hard as possible in a cost-effective way for the client. That's what I look to do. Particularly at this stage of my career, I like to represent those entities with whom I can develop lifelong relationships with, somebody that we're going to have a lifelong relationship with. And that's where I get the most pleasure of solving the problems for people that I like.
And he does. Without giving away any details, I brought him in a number of years ago to a client of mine that was having an issue, and the magic he worked, the magic you worked, I'll talk to you, not the audience. The magic you worked on that was pretty incredible. And we both know what I'm talking about. It had nothing to do with hygiene, as far as I know.
Not in that.
Where should people go if people want to find out more about you, more about Fox Rothschild, where should they
I mean,
go?
they can Google me at Mark. I use a middle initial, but I'll still pop up.
Mark with a C.
Yes, MARC, Mark Gross, GROSS. You'll Google me, you'll find my bio, my contact information. I prefer, I'm an old fashioned guy, so I prefer a phone call over an email. You just call me and I'm happy to talk, meet. I like to meet everybody that I'm representing. I had a client in San Diego. I flew out there to make sure I met them face to face. That's just how
Oh, you poor guy. You had to go to San
it wasn't
Diego.
fun, to be
Oh,
honest. It's not fun because you fly out early in the morning, you come back that same day. But I like to see and sit face to face at some point with everyone I'm representing. And so I would just urge, just call me, let's talk, let's meet, let's see if it's a fit for both of us. And I'll do my best to zealously represent your interests.
beautiful. Well, hey, thank you for answering some of the questions. You're a lawyer, you can't answer every, there's too much gray area, but that's why you get
Especially
paid so
without
much to do what
qualifying,
you do.
nothing that I said constituted legal advice. And don't rely.
Yeah. So in other words, if you're still listening, forget everything you heard on this podcast. No, but Mark, this was great. I always say, if you want a great company, you need a great leadership team. This stuff is a really big part of it. So Mark, thanks for helping us get there today.
My pleasure. See you soon, Mike, over some pancakes and eggs for breakfast.
Absolutely.
Okay.